This video examines the labor law case, Limcoma Labor Organization versus Limcoma Multipurpose Cooperative, decided by the Supreme Court in 2021. We will explore the key legal issues regarding bargaining unit exclusivity, the interpretation of CBA benefits, and the proper sourcing of profit-sharing schemes. In this first part, we look at the factual background of the case, focusing on the relationship between the parties, the memorandum of agreement, and the evolution of the collective bargaining agreement. The Limcoma Labor Organization is the exclusive bargaining agent for regular rank-and-file workers. Supervisors and managers were explicitly excluded. In 2005, a voluntary retire-rehire program was implemented, increasing profit sharing from 15 to 18% for covered employees. The core dispute concerns Article 8, Section 2 of the CBA, which granted an 18% profit share to all regular employees. Conflict arose in 2014 when the union discovered a separate contract granting a share of that same pool to managers and supervisors. The case underwent a lengthy procedural journey. A voluntary arbitrator initially ruled in favor of the union. The Court of Appeals later reversed this, but in 2021, the Supreme Court granted the union's petition, ultimately reinstating the arbitrator's original decision in full. This table compares the rulings across the different forums. The Supreme Court ultimately clarified that profit sharing for non-members must come from a separate budget, and affirmed that the proper remedy for challenging a voluntary arbitrator's award is a Rule 43 appeal. Now, we will move into Part 2, where we analyze the key doctrines established by the Supreme Court regarding contract interpretation and management prerogatives. The economic heart of this dispute was the 18% profit-sharing pool. The court held that while management has the prerogative to provide benefits to non-bargaining employees, they cannot dilute the specific pool negotiated by the union for rank-and-file workers. Key doctrines include the principle of privity of contract, which binds the CBA only to the certified unit. Furthermore, because managers are barred from joining the union, they cannot claim benefits from a rank-and-file CBA. General clauses must be interpreted in context. Regarding management prerogatives, employers maintain the right to grant incentives to non-bargaining staff. However, these must be funded by a distinct management budget. They cannot be drawn from the 18% share specifically reserved for the union members. In terms of remedial law, the court clarified that Rule 43 is the proper mode of appeal for voluntary arbitrator decisions. While a Rule 65 petition was improperly filed here, the court relaxed technicalities due to the public interest involved in labor rights. This concludes our review of the Limcoma case. Thank you for following along with this video in our labor law series. Here are the image sources used in this video.